Hey everybody, this is Deb with Truthification Chronicles, and today, which I'm recording this on June 17th, the Supreme Court of the United States, or SCOTUS as we like to call them, came out with 4 new decisions. Now remember, I showed you before that they have a calendar where, here's their calendar, you can keep track of when they're making their decisions, but as for their argument days, they finished those in April. I mean, their last argument day was, I think, April 23rd or 24th, somewhere in there. And so everything since then has been working on discussing things and trying to figure out what the end result was going to be. And so that's what they've been working on. Here are their conference days are in green here, and in blue are the non-argument days, because again, they don't have any argument days left. And so these are the 4 decisions they came out with today. Now, they may not look real interesting to you. However, I want to point out this one particular one, this Gamble v. United States. And again, if you look at the description here, it says the dual sovereignty doctrine under which 2 offenses are not the same offense for double jeopardy purposes if prosecuted by separate sovereigns is upheld. Okay, doesn't sound like much, right? But this is an important decision. And part of the reason for that is explained very well by Justice Thomas. I mean, this guy has been doing some awesome stuff, but it's usually buried in the rest of the document so people don't notice it. Okay, because like when they put this out, it's 88 pages long. And, you know, the very first part of it is where they give their decision. And this was a basic decision where this guy named Gamble had pleaded guilty to a charge of violating Alabama's felon in possession of a firearm statute. So he was a felon in possession of a firearm. Federal prosecutors then indicted him for the same instance of possession under federal law. And so there were 2 different things. Now, if you know the whole idea of double jeopardy, it's that you can't be tried for the same offense. Well, this is what it goes on and says. Gamble moved to dismiss, arguing that the federal indictment was for the same offense as the one at issue in his state conviction, thus exposing him to double jeopardy under the 5th Amendment. The district court denied this motion, invoking the dual sovereignty doctrine, according to which 2 offenses are not the same offense for double jeopardy purposes if prosecuted by different sovereigns. And when it talks about the different sovereigns, that means the state and the federal government. They're 2 sovereign entities, and so they are separate. And that's why the court decided that, yes, he can be tried on both crimes because they are 2 separate sovereigns, okay? And so that's what this whole case was on, and that's how they ended up ruling. Well, you know, it goes on and it talks about all these different cases and a lot of legal speak here, a lot of things. And they mentioned this right here. Okay, now I'm one of those people that I know some Latin, but unfortunately it gets me into more trouble than it does helps me. Okay, because when I learned how to pronounce Latin, I never pronounce it the same as the lawyers pronounce. So I always check it out. And I went over here to Merriam-Webster, and I like this because they always give me a little pronunciation. You know, so I don't know if you can hear that or not, but stare decisis is the word, stare decisis. Well, look what it, defines it as: a doctrine or policy of following rules or principles laid down in previous judicial decisions unless they contravene the ordinary principles of justice. Okay, so essentially using precedents to make their decisions. And this is something that, I've pointed out before, that a lot of times they put all these different cases that show a precedence for that kind of decision that will help judges in the current case that they're working on, have some idea of what previous courts have ruled on similar type cases. So that's what this all is. It's all about precedents. And so when you hear this stare decisis, that's what it means. And then it gave a couple of instances of it in a sentence. And they were 2 quotes from the same author, but he had 2 different articles that were from the Wall Street Journal. And the first one, the quote says, "In this sense, Roe can likewise be a good test of a nominee's views on stare decisis." Okay, on precedents. And then he went down here and it says, when the day comes that the court reconsiders Roe, the justices will no doubt take seriously the arguments from stare decisis for leaving it be. So that's the two quotes. And one of them was from July 2nd. And the other one, and this was the article here. Yep, the A word, Roe and Trump. Okay. I didn't read any further than this because I don't have a subscription, so I don't know what the rest of it said. But whenever a Supreme Court seat opens up during a Republican administration, headlines start warning that American women will soon be in for a new dark ages if Roe v. Wade, the landmark 1973 decision legalizing the A word across all 50 states, is overturned. This time around, with Justice Anthony Kennedy's retirement, the fifth vote to overturn Roe has just become a numerical possibility. Unfortunately, what ought to occasion a healthy debate over a contentious issue once again looks to be clouded by a handful of dubious orthodoxies. That's all the further I can read. All right. So that was the first article. And then the second article was in October. I think it was October 1st. And it was October 1st. And yeah, destroying Brett Kavanaugh. Nice, huh? And this is what Democrats do when they think Roe v. Wade is at stake. As malignant as were the campaigns against Supreme Court nominees Robert Bork and Clarence Thomas, even they didn't face accusations as vile and unrelenting as the unsubstantiated charges against Brett Kavanaugh. And I'm sure you all remember that. Adding to the injustice is that the frenzy surrounding his nomination isn't really about him. It's about Roe v. Wade. The 1973 Supreme Court decision upended the laws of all 50 states on behalf of a constitutional right to the A word the Constitution somehow neglects to mention. So, it'd be interesting to read these articles and actually see what he had to say, because it does sound very interesting. But I was a little astonished when I saw that, on Merriam-Webster, that those were the two quotes they used. So, yeah, the stare decisis is going to play a big role in this. And that is kind of the topic that Justice Thomas took. Now, he was with the rest of them. I think they all, if I remember correctly, where does it say? Does it say? I don't know. I'm pretty sure that they all voted for this, that they supported this, except for Ginsburg and Gorsuch. Yeah, I don't know why Gorsuch didn't. He may actually, I didn't go all the way to the end, so he may actually have had opinion down there, a dissenting opinion. But I know Ginsburg does. But I didn't read it. I'm getting tired, and I read all the way through this other. But anyway, we're going to go to page 35, because 35 is where Thomas starts his, interesting little perspective on this. And he was concurring, so he did support what the decision was. But, some of the things he points out are, I think, opening the door for a challenge to Roe v. Wade. Because his basic concept is we have to look at our Constitution, and that we're not under a common law anymore. And, of course, we're not entitled to interpret the Constitution to align it with our personal sensibilities about unjust prosecutions. So he kept mentioning that all over. I write separately to address the proper role of the doctrine of stare decisis. And this is very interesting. This whole thing is really about that, which, remember, stare decisis means precedent, that they're following other precedents that have already been set. And this is the problem with Roe v. Wade. There have been several who have spoken out about this, and I believe Thomas has spoken out about it before too, that he believes that Roe v. Wade was not adjudicated constitutionally, that the constitutional reasons behind it were not correct. They were erroneous. And because of that, I really think if you read through this, and I'm not going to read through all of it because, it does get kind of long and there's a whole lot of these kinds of things. all these different cases he refers to, which is kind of funny, a little ironic when you think about it, because the whole thing's about using precedents, and then he uses precedents to make his point. So anyway, when he is going through this, I want to, go down a little bit, but he mentions that there needs to be a special reason over and above the belief that a prior case was wrongly decided to overrule a precedent. Okay? So there has to be reason. The court has advanced this view of stare decisis on the ground that it promotes the even-handed, predictable, and consistent development of legal principles and contributes to the actual and perceived integrity of the judicial process. Now, that's what they're saying. This is, it kind of keeps our courts being more consistent if you always have to refer to some precedent. But he points out this approach to stare decisis might have made sense in a common law legal system in which courts systematically developed the law through judicial decisions apart from the written law. But our federal system is different because we have a constitution, and our constitution is firm. Our laws and our judicial system have to revolve around that constitution. They cannot contradict it. And that's something that makes us different from the common law. And that's really what he's talking about here, making it all sit down. Have to understand that I like what he says here. A proper understanding of stare decisis in our constitutional structure requires a proper understanding of the nature of the judicial power vested in the federal courts. That power is, as Chief Justice Marshall put it, the power to say what the law is in the context of a particular case or controversy before the court. Phrased differently, the judicial power is fundamentally the power to decide cases in accordance with law. It refers to the duty to exercise judicial discretion as distinct from arbitrary discretion. That means two things. The first, prohibitory, and the second, obligatory. First, the judiciary lacks force, the power to execute the law, and will, the power to legislate. And that's because those powers are vested in the President and Congress, respectively. Judicial power is never exercised for the purpose of giving effect to the will of the judge, always for the purpose of giving effect to the will of the legislature, or, in other words, to the will of the law, and therefore to the will of the people, right? The judiciary thus may not substitute its own pleasure to the constitutional intents of the legislature. So they can't legislate from the bench, all right? That's what he's reminding them of. Second, judicial discretion requires the liquidation or ascertainment of the meaning of the law. At the time of the founding, to liquidate meant to make clear or plain, to render unambiguous, to settle differences and disputes. And I'm skipping all the references there, sorry. Therefore, judicial discretion is not the power to alter the law. It is the duty to correctly expound it. Okay, very important. I seem to remember somewhere reading that Justice Thomas believes that Roe v. Wade was incorrectly decided according to the Constitution. So I think that he is making a case here for the almost certain time when that case is challenged. Because we know a lot of these laws that are being, presented in different states are going to be challenged. In fact, they are already being challenged. And so it's going to end up at the Supreme Court, I'm sure. And this is going to be a question that they're all going to have to decide. So yes, it will get to the Supreme Court. And that's where they're going to have to decide whether the stare decisis was accurate enough or not. Was it following the Constitution, or was it not solid, so it should not have been decided the way it was? Which I think that's what they would end up saying. But again, we have to remember that right now we have a precarious majority in the Supreme Court. You can never really tell if somebody's going to go over to the other side. And that's why it would be great if we had that extra seat. But, Ruth Bader Ginsburg is still hanging in there. I want to take just a minute here, okay, guys. Let's think through this whole Ruth Bader Ginsburg thing. I know people are saying, oh, well, the deep fakes. We're hearing her on the arguments, but that's deep fake. No. Okay, guys, it can't be. Think through this, because She is actually physically in the room when you hear her on this audio. Okay? Now, if it's a robot or something that looks like her, maybe, I guess, it'd have to be really good. Because either all of our justices are in on this, which should horrify all of us, or it's really her. But there's more to it. I mean, she's not in great health. So I don't know how much longer she's going to last. I'm pretty sure she's going to do the best she can to stick it out until at least like February of next year. I think she probably figures that if she can wait until then and step down in February, it'd be like when Antonin Scalia died in February of that election year. So they then would be able to block any nomination until after the election. So I think that's probably what they're going to try to do, and that they're hoping that that will take them through all of this discussion about Roe v. Wade. That's my thoughts on it. But anyway, so yeah. This whole thing when he's talking about this stare decisis, though, you know, he's saying precedents and rules must be followed unless flatly absurd or unjust, because a judge must issue judgments according to the known laws and customs of the land and not according to his private sentiments or own private judgment. So he's not, you know, trying to say that because he thinks a certain way, but I think he's setting up the legal argument and the precedents that he, you know, when the Roe v. Wade stuff comes up, that they'll be able to say, you know what, I know what the precedent says, but we don't think the precedent is constitutional. And so I think they'll be able to say the decision that was made before on it was not correctly done. And so there are good reasons to overturn it. Can you imagine what would happen if they overturn Roe v. Wade? Oh, wow. Wow, wow, wow. Now, I do want to point out to you that, you know, my mom told me, we were discussing this one time, and she told me that even before Roe v. Wade was decided, that if a woman's life was in danger, then yes, that she could still have an A if she needed it, and, you know, to save her life. The difference is it would not be used as a birth control method. And just killing children willy-nilly just because, what, you don't feel like having a child today? I don't know. So, anyway, when it goes on down, let me go down to, I'm sorry about all this spinning here. Make it stop. He makes a lot of really good points. And, you know, in sum, my view of stare decisis requires adherence to decisions made by the people. That is, to the original understanding of the relevant legal text, which may not align with decisions made by the court. It's very interesting, huh? It has to be according to the law. Thus, no special justification is needed for a federal court to depart from its own demonstrably erroneous precedent. You know? Considerations beyond the correct legal meaning, including reliance, workability, and whether a precedent has become well embedded in national culture, and that was something Stephen Breyer said, are inapposite. In our constitutional structure, our role of upholding the law's original meaning is reason enough to correct course. Although precedent does not supersede the original meaning of a legal text, it may remain relevant when it is not demonstrably erroneous. As discussed, the judicial power requires the court to clarify and settle, or, as Madison and Hamilton put it, to liquidate the meaning of written laws. So that's what they're supposed to be doing. And I think that's what he's standing firm on here and pointing out. And like I said, I just see this as a way to set up what's going to happen when the Roe v. Wade things are being challenged, because those cases are coming up. And yeah, they're going to be in there. So anyway, it goes on to about page, 51, I think it is. So yeah, because he does a little summary here. 51, just a minute. Sorry. I know, drives you nuts when I do that kind of stuff, doesn't it? So this is his little summary here at the end. Our judicial duty to interpret the law requires adherence to the original meaning of the text. For that reason, we should not invoke stare decisis to uphold precedents that are demonstrably erroneous. And that's going to be the key right there. That phrase, because I think this is what they're seeing it as, or at least he is. Because petitioner and the dissenting opinions have not shown that the court's dual sovereignty doctrine is incorrect, much less demonstrably erroneous, I concur in the majority's opinion. So he brings it back to the topic at hand. And of course, he didn't say anything really about Roe v. Wade in here. But I think that's what it's kind of setting up the foundation for what they're going to need when that comes to the court. Because you know that these people understand, all these justices, they know that that's going to come before them. They're already studying up on things. And so I think this is one way that Thomas is putting the information out there. He's such an incredible man, really, because he doesn't ask questions hardly at all. I think he asked one question during the oral arguments for the citizenship question on the census. And that was the first time in months that he had spoken, or even in years. I mean, he hardly ever asks questions during the oral arguments. So, for him, I think, feels more comfortable writing, and he does a really good job putting his thoughts in the opinion. And I was surprised to see this, to be honest, because when somebody concurs, they usually don't write something in addition to what the, majority opinion was. And so for him to do that, I thought it was kind of unusual, and I wanted to see what he had to say. And it is a good read, but it's kind of long. And then after this, you get into Ginsburg, and like I said, I didn't get into her, but she was a dissenting, and so was Gorsuch. So I don't know why Gorsuch dissented, but maybe he thought the precedent was, valid or something. So anyway, that's what I wanted to share with you. I think it's definitely worth reading if you want to, but his goes from page 35 to 51 of the text. And as always, I'll put the links down below so you can read it for yourself if you want to. It's not, if you skip over like all the documentation, all this stuff here, and the cases and things, it goes pretty fast. It's a pretty fast read because they have these huge margins on each side. So, it does go pretty fast. But anyway, I just wanted to share that with you and let you see what was in it. And keep this in mind, because when those cases start coming up, I think we may actually see a question about the constitutionality of how the entire precedent of Roe v. Wade was decided. And that could change a lot of things if that's overturned. So anyway, that's what I've got for you tonight. I want to thank you for stopping by, and I'll see y'all later.